UK, USA, Tax Talk and More from Collier Bristow. Welcome to the Collier Bristow series, UK, USA, brought to you by our tax and estate planning team. The series discusses a range of private wealth matters, all with a US flavour. In this latest episode, Senior Associate Aidan Grant is joined by James Cook, a partner in our private wealth team. Together they discuss the meaty topic of death, including the taxes that arise on death, as well as the probate and estate administration processes. Reflecting their individual specialisms, James and Aidan also look at how the UK and USA approach these matters differently, and what issues clients with mixed UK and US affairs should be alert to. We hope you enjoy the episode.
Welcome back, ladies and gentlemen, to the third episode of Collier Bristow's US-UK podcast, a series designed to help navigate the perilous waters of UK-US private wealth matters. If you haven't had a chance to listen to our first few episodes, then please do go and have a listen. Presumably in the first place you found this episode. We've looked at various topics with both Collier Bristow colleagues and guests to the podcast. Today we are looking at the issue of death, the taxes that arise on death and probate, and estate administration. Let no one say we don't have fun in this industry. We will look in particular at how the US and UK approach these issues differently and what those individuals who are left to administer estates in the UK, but which involve US elements, need to know. We'll also look at how the impact of UK tax can vary significantly from estate to estate with Americans. My guest today is James Cook, a partner at Collier Bristow, and who, along with me, sits as a member of our private wealth department and in the tax and estate planning team. James, thank you so much for being here today. Would you like to introduce yourself?
Lovely. Thank you for having me, Aidan, today. I'm a partner in the private wealth team at Collier Bristow, and I'm more of your traditional UK private client solicitor, specialising in trust, tax, estate planning, mental capacity work, as well as probate. So I principally advise on UK tax and estate planning, but my work often includes international elements for both UK and non-UK domiciled individuals. And I have a particular focus on the more complex probates, helping clients to maximise the use of inheritance tax reliefs and exemptions where available.
Now, James didn't mention it himself, but I'm sure he won't mind me saying that he also hosts a podcast with Collier Bristow called The Art of Probate, which looks at the interaction between the art and the probate worlds. And so it's wonderful to have a fellow podcast host on this series with me. I was joking with James beforehand that this is our first official crossover, so you'd be forgiven for thinking that we were some sort of summer blockbuster superhero franchise with our crossover events. Whether we're going to be as exciting, I shall leave entirely down to you, the listener. So as ever, it's perhaps helpful to have a little hypothetical client on which we can hang some of these issues. We're going to consider today that we have Mrs. Jackson, who is a US citizen who's been UK resident for the last 20 years or so until her death early this year. Yes, unfortunately, we do have to kill off Mrs. Jackson. This is a probate episode. Her husband, who was also a US citizen, died around 25 years ago when they were both resident in the US. Mrs. Jackson moved to the UK to be closer to her daughter after her husband sadly passed away. Mrs. Jackson is survived by her two children, her daughter, who I previously mentioned, and her US resident son. Now, under her UK will, Mrs. Jackson left her estate equally to her children and appointed them as co-executors, so what we might consider to be quite a straightforward will. Mrs. Jackson has assets in both the US and UK, and we will consider, as this discussion goes on, what the consequences of that is. How does that sound, James? All sort of good from here so far?
It sounds good. Oh no, I've got that song in my head. Sorry, Miss Jackson. But otherwise, all good.
I was trying to go for US presidents. I thought each of my clients could be, I could have a Washington and a Jackson and a Jefferson, and I've unfortunately landed on a 90s R&B song the first time out. That was not intentional, but then it beats referencing Julie Andrews in every podcast, which I've done on each episode so far, and I guess I have done here as well. So just a quick look at the topics we're going to discuss today, just to sort of set out our stall. We're going to look at the probate processes in the US and the UK, and particularly the attitudes towards probate in the US and why that leads American estate planning to sometimes come up adversely against the UK system, and what it is we can do about it, either during lifetime or even after death, and just a couple of helpful hints there. We're then going to look at a really important point of US and UK tax and succession, which is the question of domicile and how that particularly impacts on estate administration and tax. we will then segue into a brief look at the similarities and differences between the death duties in the US and the UK, talking principally about inheritance tax in the UK and federal US estate tax. That is a meaty topic and maybe left in detail to another podcast episode, but a look here is still relevant, I think, in the context of probates. And then looking finally at the end, a brief look at something that comes up quite frequently in estate administration between the US and UK, which is direct inheritances versus trust inheritances, where Americans have left living trusts or revocable trusts, as they're sometimes called, and what that means for individuals here in the UK. If that sounds like a lot, as ever, we will try to make it fun, enjoyable, interesting, and not too technical. And if you're still with us at the end, congratulations. So, starting at the beginning, James, looking at the two probate processes, their similarities and the differences, where do we start with the UK? What for those of us that haven't yet had to have the burden of going through the probate process for a loved one, what do we need to know about the sort of the main points of UK probate?
Yes, of course. So I think in the case study we're looking at with Mrs. Jackson, we need to consider, is it necessary to apply for a grant of probate in the UK for Mrs. Jackson? So to go back to the very beginning, what is a grant of probate? So a grant of probate, or it's also known as a grant of representation, effectively determines who is entitled to extract the grant and confirms the validity of the will. So it identifies the individuals who are allowed to administer the estate, and then it confirms that the will is valid and that the estate can be kind of dealt with in accordance with the terms of that will. So the grant is required really to collect in assets. So with the grant of probate, you then approach the financial institutions, you approach the land registry, you approach any institution where there is an asset, and that will give the executors legal title to transfer those assets or to liquidate those assets as per the terms of the will or as per the beneficiary's wishes.
And I guess at that absolute beginning level, that is sort of the first point of similarity, which is that the UK and the US are both derived from common law and so share many similarities that say the UK system doesn't share with the French system, which is a civil law jurisdiction, and so is very different. Both jurisdictions have that concept of a grant of probate and about administering assets. Someone dies, you apply for it, and then you use that to go and collect the assets. So in that respect, it is the same. However, the issue then becomes, does it not, who is entitled to claim it? Do you need a grant of probate in both jurisdictions, which may depend on whether you have a will in both jurisdictions, and therein it starts to get stickier, does it not?
It does, and when you're looking at who is entitled, I mean, your first point of call is to look at the will. So the will hopefully identify the executors, and the executors would be those persons who are entitled to apply for the grant of probate. If the will does not identify the executors, or there is not a will, then we then have to look at the law of the land. So in this instance, we'll be looking at we come to the point of domicile here, but for UK or English purposes, we'll be looking at the intestacy rules, and the intestacy rules will specify the order in which an individual is entitled to apply for the grant of representation, also known as the letters of administration. So in this scenario, Mrs. Jackson has died, Mr. Jackson predeceased her, she left two children, so I presume, well, you've already specified in the case study that the children are the executors. If there was no will, then the children would be those individuals who are entitled because they are the next closest relative. They're also the beneficiaries of the estate. But focusing on that point, at what point is it necessary to apply for a grant of representation, or is it needed? And this will really come down to the assets in question. So you don't need to apply for a grant of representation in all situations. You only need to apply for a grant where it is necessary to collect in those assets, transfer those assets. And I presume that's the same in the US, Aidan.
Yeah, broadly that's the same. And just as a terminology clarification, because it does come up occasionally in the probate process, we talk about the probate process with a sort of a lowercase p, meaning the administration of an entire estate. You then have a grant of probate, which is the specific document, which is one of a number of documents that can be used to affect the gathering of the estate that bequeaths the official responsibility on the executors. It is one of a number of documents. Letters of administration that you mentioned is another document where you don't have a will, and those are all collectively referred to together as grants of representation, are they not? So just sort of, you may hear us talking about grants of probate generally in this episode. That is sort of shorthand for all of these different forms of grants, depending on which one is relevant in the circumstances.
Are the same terms used in the US as well?
A grant of probate is certainly the term. I forget what the term would be in America if you didn't have a will. The process is I believe still the same. That's why we might refer to grants of probate here for convenience. Advice should be taken in the specific circumstances. What document is that you need? Because as I said, it may not be called a grant of probate in that particular scenario.
So then, if we come back to whether or not the grant of probate is needed, I mean, we look at the assets. So in the UK, if Mrs. Jackson say only had a small bank account, then you'd often find that a grant of probate is not needed and that you could approach the bank directly. The bank will have its own de minimis rule where they would say if the balance is less than, say, £25,000, £5,000, and all banks are different and the rules vary, then they release the funds without a grant of representation or grant of probate. Yeah, I mean, that's broadly speaking where we are. And again, this is the same applies in the US.
Yeah, the same will apply, and it very much depends by sort of institution to institution how much they will permit. They have to consider their own administrative costs of dealing with these things, and if there's pounds and pence or dollars and cents sitting in a bank account, it's not worth their time demanding that someone has a grant of probate. However, if you have tens or hundreds of thousands of dollars sitting in an account, you're probably going to have to go via other means. But that comes more broadly to a wider issue about US attitudes towards probate, which we'll come to in a little bit. Here in the UK, everyone accepts that you're going to go through probate. Everyone accepts that this is a necessary step. And so it doesn't tend to come as a shock to sort of financial institutions that someone's going to need to come forward with a grant of probate. And it's just a done thing, except in circumstances where the bank account is quite small.
Yes, I think that's fair. And I think the difference, or one of the main differences between the UK and US is really down to time frame and cost as well. In the UK, we estimate somewhere between 3 to 6 months from the start in the probate process to obtaining the grant of probate. And there are timeframes within that we can go into more detail later. But then in terms of court fees, we're looking at £155 at the moment, or no, that is likely to go up in the very near future. So £155 to apply for the grant of probate in the UK. I understand that that's dramatically different from state to state in the US.
The problem with the US, as exactly as you say, is that the process, like most things to do with US law, vary by state to state. Certainly in states such as New York and California, the attitudes towards death and probate are that probate is to be avoided at all costs because it is a lengthy, costly, and time-consuming process and energy-consuming process that involves going through the courts. And that is a process that will take a lot of time away at a time when the family may be going through, grief and don't want to be devoting that time, cost, and energy to that process. Thus why you end up with many wealthy Americans leaving assets in a revocable trust so that title doesn't need to pass on the death of the individual. That is the issue we will come to at the end of this podcast and the consequences that flow from that. But it is that differing attitudes towards probate in both jurisdictions that give rise to some of the differences between the two jurisdictions. However, one of the discussions we have with practitioners and clients who have American interests quite frequently is trying to convince people to leave what we call sometimes their free estate, assets that pass under a will, to leave their free estate in their own names rather than leaving assets in a trust, because the probate process may be complex in America, but the UK tax consequences of leaving assets through a trust will far outweigh those probate costs. And so there's a bit of a push and pull between the UK interests and the US interests. And ultimately, it's the client's commercial decision, what they want to leave their family. If they want to leave their family with high administration costs but lower tax, or higher tax and lower administration costs, only a client can make that decision. But it is a perennial problem that is going to affect every client.
Yes, absolutely. We have the focus on whether or not the grant of probate is required. But the other point is the will, and whether the will is acceptable for the English courts, and whether the will is acceptable for the US courts. I mean, generally speaking, the US and UK have very similar rules on the formalities of their will. Again, I think you'll tell me this is different, Aidan, but from state to state it may vary. But largely speaking, a US will is acceptable in the UK and vice versa. In Mrs. Jackson's scenario, she prepared her will in the UK, at which point she was most closely connected to English law, and at that point it will be accepted in the UK for that purpose, because she prepared the will in accordance with the law that she's most closely connected to. If she prepared her will before she moved to the UK, then we would have a slightly different issue there, because she would have prepared it as a US citizen, and she would have prepared the will in the US as a US citizen. An English will prepared by a US individual in the US at the time of preparing the will wouldn't necessarily be valid under English law unless it conforms with the English formalities. Now, we know that, broadly speaking, and it varies from state to state, that it will likely conform. But at that point, we would need to obviously obtain some proof or an affidavit of law to show that the US law it has been followed in terms of the preparation of the US will, which can then be proved in the UK court. You have to go around the houses a little bit to work out exactly whether or not the will can be proved within the English courts. But broadly speaking, the UK and the US, as Aidan said earlier, they follow very similar rules, and we derive our laws from common law. So we have similar principles in that sense.
And it's worth remembering that clients make wills for a number of reasons, but if a client's been in the UK, certainly by the time Mrs. Jackson was in the UK, for some 20 years, your plans are going to change, your wealth is going to change, your family is going to change, and you're probably going to want to update your will more than once every 20 years. You would certainly, James, I imagine, as a partner who does this very frequently, wants to advise clients to update their wills more than every 20 years. So inevitably, provided a client doesn't come to the UK and then die with their existing will, at some point they're eventually going to create a new will anyway. It's only to reassure people that if the worst does happen and a will has not been prepared in the UK, it's still probably fine. It's just there's an additional administrative step that has to be carried out. It's not that there's usually going to be any question of there being a problem. 99 times out of 100, it's probably fine.
Yeah, that's correct. That's correct. The one point we should mention here is the whole point of the grant in the US and whether or not a US grant can be used in the UK. I mean, strictly speaking, the answer is no. We do have a rule with other Commonwealth countries where you can effectively reseal. So you can take a foreign grant, probate, and reseal that document in an English court. That doesn't apply, obviously, to US in this instance. So we can't use it for that. So, I mean, that would be the only point there on the grant point. But from the will, it looks as if Mrs. Jackson's will is going to be fine, and Mrs. Jackson's will can be proved in the UK and can also be proved in the US if necessary.
UK, USA. Tax Talk and More from Collier Bristow.
So let's assume that we've got the grant of probate out of the way. Let's take a step back, actually probably slightly earlier in the process, and reflect on domicile and why it's so important. I say take a step back in the process because here in the UK, the application for the grant of probate and considering inheritance tax need to happen concurrently, because you can't get a grant of probate until you've paid your inheritance tax, which is a catch-22 that catches a lot of people out. So we are sort of going slightly backwards in time thinking about domicile now, but it is a huge topic and it is one that deserves attention and focus. And so let's turn to it now. I guess the first thing to say that's very important before talking about its consequences is to reflect on what do we mean when we say domicile, because domicile also means different things in the US and in the UK. Domicile for English law purposes generally refers to where someone considers their main permanent home to be. It's a state of mind, it's an intention, but it's very hard to demonstrate intention. And so the way in which UK law really applies that intention is by looking at the facts and circumstances available to say, what do the facts show were this person's intention? It's a nebulous concept. It's something that lawyers often get bogged down into, but that is what we mean when we talk about domicile. It's very different to US forms of domicile, which can include, for example, citizenship. Here in the UK, citizenship is a very, very, very small part of the puzzle of what makes up domicile. Nothing is irrelevant and everything is relevant. Is that a sort of a fair summary, James?
Absolutely. I mean, domicile is one of those points that gets private client lawyers quite excited because it's such an interesting point. It's so subjective. There's so many different arguments you can have with it. But the way I look at domicile is for an English purpose is where you belong. So where your heart is, where you feel that you are, where you really feel your roots are. So in this instance, for example, Mrs. Jackson, and we come to the whole concept of domicile, and domicile is relevant both for succession as well as for tax. But in her heart, Mrs. Jackson may feel that she's still very much a US individual, and that the US is where she has the closest connection to. The US is where she wants to return to in the future. So it may be that for succession purposes, Mrs. Jackson has never relinquished that domicile. Yes, for tax purposes, it is slightly different, and we come to that because irrespective of where you belong and where you feel your domicile is and where your domicile actually is, in UK law, you could still be taxed in the UK as a deemed domiciled individual if you've been in the UK for a set period. And no doubt we'll discuss that in briefly when we focus on the tax side. But on the domicile of regarding succession, we really look at where your individual belongs. Each individual has a domicile of origin. Each individual starts off with the domicile of their father. So in this case, Mrs. Jackson, I presume we're going to make the presumption that her father was a US individual. So she would start off with a domicile of origin in the US. She can then relinquish that domicile by acquiring a new domicile, a domicile of choice, or even we can focus on a domicile of dependency. But on this basis, her husband has passed away, and that's quite an archaic law that we don't focus too much on anymore in terms of domicile of dependency through marriage. If we focus on domicile of origin, starts off with the US, she moves to the UK. Has she acquired a domicile of choice in the UK? That's really a question of fact, and whether or not she sings the national anthem, whether or not she supports an English football team, where her family are based, where her assets are based. There are lots and lots of questions that we can address there, her education, her employment. There's so many different factors that we go into, and it's a very subjective element there.
Yes, I completely agree, and it wouldn't be impossible for HMRC to try and claim that Mrs. Jackson came to the UK, spent 20 years here to be close to family. Her husband had passed away. Had she started to lose ties to the US, she came here and ultimately died here. Where you die and where you intend to die can, from HMRC's perspective, often form quite a key part of your domicile, because people like to be in their home at the end of their lives. So it would not be without question that HMRC could claim that Mrs. Jackson was domiciled in the UK at her death. As we will go on, as James pointed out, from a tax perspective, it's moot because we know that she's going to be taxed as a UK domiciliary. In terms of succession then, James, why domicile is so important? Perhaps you might explain to people the difference between explain how domicile affects the devolution of various assets on death and why it is that we want to consider domicile carefully, particularly for Mrs. Jackson.
Yes, I mean, the starting rule is that the succession of your estate is governed by your domicile. So we all start off on the basis that your assets so Mrs. Jackson, let's say she is UK domiciled, she acquired a UK domicile of choice. So therefore we would focus on the point that her UK assets will be subject to UK succession rules. Her global assets will be subject to UK succession rules, and other than those immovable items. So those immovable items will be real estate, and those will be subject to the domicile of where they're situated. So in this instance, the US assets, if she had a US real estate, and then in theory, the succession rules state that the situs of those assets, so the US domicile rules apply to the succession of that asset. Of course, by nature of her will, the will governs exactly where they are divided. And the UK and US have very similar rules in terms of freedom of this disposition. So it doesn't make too much difference between the UK and US elements here, but it would make a difference. For example, we had a French asset. We've moved away from the whole concept of Brussels 4 because we're not going to focus on that, and Brussels 4 just it's probably a tangent I don't really want to go down, but it broadly speaking, it states that you can apply the succession rules of your nationality to that asset. But if we work on the basis that the French have forced heirship rules and that you have to leave assets in a certain way. If you have a real estate asset in France, then the starting position is that the French laws will govern the succession of that asset for a UK individual, unless there is contrary evidence to say that it should devolve in a way.
Yes, I think the French example is a starker one, but it is worth pointing out here. Let's say, for example, that Mrs. Jackson had a condo in America that she'd retained throughout her life. We in the UK would say that passes in accordance with the law of the country in which it's situated. What we in the industry like to refer in the Latin as the lex situs, as opposed to the lex domicilii. The lex situs is the US, but specifically is the state in which the condo is situate. So if it's a New York condo, it would be New York law, and so on and so forth. That could impact on a number of different ways. For example, I believe it is still the case that one of the states in the US has a degree of forced heirship rules. I want to say it's one of the southern states like Louisiana or something, because of the French influence, still has a degree of forced heirship. But even something like intestacy, Mrs. Jackson has a will here, but let's say someone died intestate and didn't have a will, then correct me if I'm wrong, James, but we would say that the intestacy rules that apply would be the intestacy rules of the US state in question, would they not be? In which case,
Yep.
if you leave, for example, a spouse and a child, we say in the UK, well, the spouse and the child divvy up the assets in a certain proportion, but those proportions could be different in the US, and it could therefore affect how people inherit. So it is still worth thinking about, even where we have two jurisdictions that operate on broadly similar principles.
Absolutely. And I think it reiterates, and I'm a big advocate of this, it basically highlights the importance of a will. So you really do need to have a will to decide on the succession of your estate, and a valid will at that, to ensure that it applies in more than one jurisdiction if that's required. But in this situation, Mrs. Jackson has a will, and the will specifies the succession of her estate. So we're okay there. But in terms of the tax element is very different here. And you can be domiciled in the US, but still be domiciled in the UK for tax purposes. And that's known as what's called the deemed domiciled rule. So if you're basically tax resident in 15 out of the last 20 tax years in the UK, then for that reason, your worldwide estate is subject to UK inheritance tax. So that's the key there. If you are domiciled in the UK for UK tax purposes, then your worldwide estate is subject to inheritance tax. If you're non-domiciled in the UK, then only your UK situs assets are subject to UK inheritance tax. So that's a big difference there. And we'll go on to the rates of inheritance tax later on in this podcast, but it's a big difference there.
If there's one takeaway point that I think Americans in the UK needs to know, or if you know someone that's an American living in the UK, it's that an American is taxed according to their citizenship. So an American living in the US, their global estate is taxed to US estate tax. An American living in the UK, their global estate is still taxed to US estate tax. It makes no difference for those purposes. If that American is here in the UK and they've only been here for a few years, then absent them becoming actually domiciled here under English common law, the type of which James and I described previously, they're not a UK domiciliary, and therefore only their UK estate is taxed to inheritance tax. And even then, caveat, the US Gift and Estate Tax Treaty may offer further relief. Once an American has been here for long enough, we will consider them a deemed domiciliary. It used to be that you became deemed domiciled once you've been resident for 17 of the last 20 years for inheritance tax purposes. It's now 15 of the last 20, so they've brought the number down slightly. So if you've been here for more than 15 years, you have to be prepared that the UK government is going to try and take quite a large chunk out of your estate, which will include your US assets, unless you've taken appropriate steps beforehand, such as a tax-efficient will or other things that James and I would be delighted to talk about at great length on another episode. So that is the point to be known. Just because you think, I'm an American citizen, I'm taxed in the US, therefore I know I'm always taxed in the US, and I've got an $11.7 million allowance, that's not necessarily going to cut it with the revenue here. They'll tell you, you've been here long enough, we're also going to try and tax you. And guess what? Our allowances are a lot lower. We will come on to that point shortly. But that takeaway point, I think, is really worth stressing again.
And there's another quirk to add to that as well. I mean, and Aidan, do correct me, but in the UK and the US, you have spouse exemptions. So assets passed from between spouses is generally free of inheritance tax or estate tax in the US. And I think that's the case in the US, but Aidan will no doubt correct me. But in the UK, for example, assets passed from between spouses, unlimited spouse exemption. So you can pass as much as you like between spouse, and there's no inheritance tax to pay. However, that doesn't apply where you've got a domiciled, so UK domiciled spouse leaving assets to a non-UK domiciled spouse. And in that case, that spouse exemption is limited to £325,000. So this endless pot that you can pass between spouses is limited, where you're passing from a domiciled to a non-domiciled individual. That isn't fatal fundamentally, because you can apply, so the non-domiciled individual can apply to be domiciled in the UK for the purpose. So for example, if in this situation, if it was the other way around and Mrs. Jackson, UK domiciled, died first, and then Mr. Jackson died second as a US domiciled individual, Mrs. Jackson passing everything to Mr. Jackson, then on that point, Mr. Jackson, whilst he was alive, he could have applied to the UK revenue to say that I want to be domiciled in the UK for the purposes of obtaining this spouse exemption. And then he can then relinquish that within 4 consecutive years after that. He can then relinquish that domicile. But you are tying yourself into the UK inheritance tax regime for 4 years in order to obtain that spouse exemption.
In fact, you get slightly more of a generous allowance under the UK-US Gift and Estate Tax Treaty. One of the articles there says that in those circumstances that James mentioned, i.e. you've got someone in the UK leaving assets, so on, not in the UK, provided the American citizenship falls the right way in that relationship, your limited spouse exemption is in fact uplifted from £325,000 to 50% of whatever you would get otherwise. So if you were leaving £10 million to a spouse rather than getting merely £325,000 of spouse exemption, you'd get £5 million. That is some consolation. It is still not as good as getting a complete spouse exemption, but as James says, you can apply to be considered deemed domiciled. And then, as James said, you have to wait 4 years to escape that net.
UK, USA. Tax Talk and More from Collier Bristow.
Since we seem to be skirting around the edges of death duties, let's look at them a bit more closely. As I mentioned at the top of the episode, when we're talking about death duties here, we're really talking about inheritance tax here in the UK and specifically federal estate tax in the US. I guess it's important to point out here again that, like I've mentioned in previous episodes, different states have different rules, and it is certainly the case that certain states levy a state estate tax. I think a couple even have a state inheritance tax. If you want to know the difference between a state inheritance tax and a state estate tax, I'm afraid I don't know the difference, and I imagine many US attorneys don't know the difference either, but the answer is probably out there. So the differences between estate tax and inheritance tax, again, generally speaking, they are levied in the same way. They are a tax on the estate. It is not a tax paid by the recipient, unlike in some civil jurisdictions. So the estate pays the tax and then assets get distributed to the beneficiaries. It is levied subject to a tax-free allowance. Those tax-free allowances differ massively between the two jurisdictions, and we will come on to that, but it is then levied above that allowance at currently the same rate of tax, give or take, which is 40%. So conceptually, at the outset, very similar, James.
No, that's interesting to know from my perspective. I mean, it does vary, I presume, from state to state as well, because each state will have their own tax.
Exactly. So different states will levy different things. A lot of states peg their state estate tax to the federal estate tax allowance, what they call the unified credit allowance. Unified credit because it relates to both your gift tax during your lifetime and your estate tax on death. Your unified credit allowance is currently in the US, as at the time of recording, $11.7 million, I think it still is. It was inflated in 2018 under the Tax Cuts and Jobs Act by the previous Trump administration. And it is due to come back down to its pre-2018 levels of roughly $5.5 million at the end of 2025, I think. So we are in the middle of an inflated bubble. But contrast that with the UK allowance of £325,000. £325,000 is considerably less than $11.7 million. And so it is important to consider that if we are carrying out tax planning that doesn't otherwise attract a marital deduction or a spouse exemption, which we'll come on to, the allowances you're playing with are very different. And it's entirely possible that you have assets passing to, say, children free of tax in the US because it's under the allowance, because you're only passing $8 million. But you have a much, much lower allowance here in the UK. And so your planning needs to be a lot lither and a lot cleverer if you're looking to mitigate the worst of the UK inheritance tax charges, or you need to rely on the US-UK gift and estate tax treaty for your tax reliefs.
Yes, and I think if we take the example of Mrs. Jackson here as well, we can apply the UK tax to that, just so you can get an idea of what of the comparison between if she was in the US or UK. So the fact she's died in the UK, she's deemed domiciled in the UK. She's been here well over 20 years. Mm-hmm. So she's subject to UK inheritance tax. I mean, the starting point is well, we're going to make a presumption here that Mr. Jackson gave everything that he owned to Mrs. Jackson. And on that basis, she obtains, firstly, the nil rate band. So the nil rate band in the UK is currently £325,000. It's been at £325,000 now since 2009, I think, Aidan.
It may have been before that.
Maybe, yeah, exactly. And I think it's still frozen now until 2023 or 2025. It's got very little prospects of going up, which is disheartening, really, especially given that Middle England's wealth has increased dramatically in that period. But yes, inheritance tax threshold has not increased. But anyway, that's a whole nother rant. So we have £325,000 as the nil rate band. Mr. Jackson died, leaving everything to Mrs. Jackson. We presume that he didn't use any of his allowance up in the UK, so we can transfer his unused portion of that, so we can get a 100% uplift in the nil rate band for Mrs. Jackson, so that we increase her 325 to by another 325 to 650. So we have £650,000 as a starting position. Now, on the presumption that she had a main residence at the date of her death, and that Mr. Jackson also had that main residence or another main residence, and that their estate is close to the £2 million mark or below that, and assets are passing to their children, then it is possible for them to get a further uplift in their nil rate band, their tax-free allowance, by £175,000 each. So we can obtain Mr. Jackson's £175,000. We can have Mrs. Jackson's £175,000. So in theory, and this is very much a conservative policy, which doesn't really affect that many people, very much a minority kind of advantage, but it sounds good on the billboards. In theory, you have a £1 million inheritance tax allowance for a married couple individual in this scenario. So there is potentially up to £1 million, which is tax-free, and then the excess above that is subject to 40% inheritance tax. There are further reliefs that you can apply where you're leaving money to charity. If you leave money to charity in the UK, then that's free of inheritance tax. If you leave more than 10% of your estate to charity, the rate of inheritance tax reduces from 40 to 36%. And there are other reliefs as well associated to particular assets that we can talk about further, maybe on a different podcast.
But I think the point needs to be made that even at its most generous, the maximum a couple can leave in the UK under current rules, using their various nil rate bands and residence nil rate bands, is £1 million. Even under the most aggressively mooted cuts to the federal estate tax allowance that the Biden administration has suggested, would lower that allowance to, let's call it $3.5 million per American. Now, in our scenario, we've made Mr. and Mrs. Jackson both US citizens, and the fact that Mrs. and Mrs. Jackson are married means that Mr. Jackson's allowance should pass to Mrs. Jackson, all things going to plan with the American lawyers. And so even under the most aggressive cut that's been mooted, we still have a US allowance of, let's call it $6 million. That's a $6 million allowance versus a £1 million allowance here in the UK. So we are always going to have this disparity in the amount of tax relief given on death. And so it is incredibly important to think about what are the other ways to mitigate taxation on death through lifetime planning. And this comes on to one of the points that James mentioned previously, which is the use of spouse exemptions and marital deductions. In both countries, like in many countries around the world, as a matter of public policy, assets left between spouses can be left free of tax. It's the case in the UK and it's the case in the US as well. However, there are lots of ifs and buts attached to that. For example, for a different episode, but I think we may have touched on it previously in another episode here, in the US, you don't have an unlimited gift tax allowance if you as an American are leaving, if you gift assets to a non-resident alien, that gift tax allowance is limited to, I forget, it's something like $170,000 per year, maybe just under that. In the same way here, as James already mentioned on this episode, our spouse exemption is limited when a UK domiciled individual is leaving assets to a non-UK domiciled individual. In both scenarios, because of a public policy reason where the various tax authorities don't want assets leaving their jurisdiction or leaving their grasp, because if you leave assets to a non-domiciled spouse, the inference is that person could go abroad and you won't see any more of that tax. However, on a general basis, assets left between spouses can be left free of tax. However, the ways in which will and estate planning works in both jurisdictions means that certain forms of trusts and certain forms of wills can leave assets in a slightly more protected way for a spouse, but in a way which continues to benefit from a spouse exemption. I'm thinking here in the UK of something like a life interest trust. In America, you might think of something like a Q-tip or a Q-dot in your will that lets you leave assets on trust for a spouse. The problem is that a life interest trust in the UK that would claim the spouse exemption in the UK may not claim the marital deduction in the US because of the way in which the US would consider the terms of that trust in the UK to be. All of which is to say, it's very important for those individuals who are thinking not about estate administration, but now thinking about will planning, that where there is potentially tax to pay in both jurisdictions because the US tax exposure is in excess of the relevant estate tax allowance in the US, that appropriate US-UK advice is absolutely sought as paramount to ensure that the planning mitigates at the very least tax on the first death and claims the spouse exemption in full in both jurisdictions, and at the very least defers that tax until the death of the second spouse when, let's say, assets passed to children. Otherwise, the surviving spouse can be left with a surprising tax on their death in one country or the other without relief under the gift and estate tax treaty, which the spouse certainly won't thank you for. So let's not put them in that position.
And I think, as Aidan said, the key to it is lifetime planning. I mean, you need to get your lifetime planning in order. You need to ensure that you're mitigating inheritance tax from an early stage if it's applicable within your estate. And in Mrs. Jackson's scenario, it's actually something that she may have already thought about, or she should have certainly been thinking about prior to her death. The other point as well as tax mitigation is to look at the particular assets. And I think Aidan may have covered this in the previous podcast, but it's worth mentioning as well that certain assets in the UK are treated differently for tax purposes in the US. So that should be another issue that one should consider. In Mrs. Jackson's scenario, we've got one beneficiary. So we say there are two beneficiaries, one child in each country, UK, US. There are certain assets which it would not be advantageous for, say, the US individual to hold. Say, for example, a unit trust in the UK is not advantageous to hold as a US individual. And vice versa, there will be certain assets in the US which a UK individual shouldn't hold. So we just need to be careful there when Mrs. Jackson's preparing her will, or even following her death when the beneficiaries are divvying up the estate over which assets they receive, which assets they liquidate, how they liquidate them. It may be advantageous, especially in the UK, but for purposes is to assign assets to the US individual before they are then encashed. That may work.
Yeah, I was just going to say, you're absolutely right, James, that those listeners who listened to the previous episode with Tanager Wealth Management, Christopher Heck and Patrick Mulhern, will remember that we spent a fair bit of time talking about financial planning and investment management for US and UK individuals. And James is absolutely right that there are certain assets that are simply, well, either tax inefficient to hold, or if not inefficient from a tax perspective, certainly inefficient from a reporting perspective. The example James mentioned of a unit trust is a very good one. Here in the UK, a unit trust is a collective investment where you report on the sale of the share in the unit trust itself. You don't report in the underlying investments that the unit trust is invested in. In the US, that's not the case, and a unit trust is a horrible investment for a US accountant to have to account for. And so in James's scenario, exactly as he mentioned, you want to think very carefully about what assets are appropriated to Mrs. Jackson's UK daughter and which assets are appropriated to Mrs. Jackson's US son. Absolutely, that is the case. And a small plug for firms like Tanager. Undoubtedly, Mrs. Jackson's executives may wish to go and seek the services of someone like that to help them get those affairs in orders.
Yes, absolutely. Or even the beneficiaries.
In this scenario, the beneficiaries and the executives being the same people. But yeah, absolutely. Particularly if there was some form of ongoing trust, particularly for minors, something where money is being managed in the long term, particularly liquid investments, the appropriate investment advice should absolutely be sought at that point. I think the other thing that is important to sort of bring focus back to, which we have sort of considered throughout this episode, is the question of tax relief under a double tax treaty. Now, if you felt that death and taxes were dry enough topics, then the concept of dealing with an estate tax treaty with respect to death and taxes is going to be even drier. So I certainly don't intend to leave discussions on this topic too long. Simply to say, it is entirely possible, as we have sort of referenced in this episode, that someone can be domiciled in the UK for tax purposes, despite the fact that they consider themselves to be a domiciliary of the US. From the US perspective, if that person is a US citizen, then they are always going to be a US domiciliary for US tax purposes. So in Mrs. Jackson's scenario, she is a US domiciliary for US tax purposes, and she is a UK domiciliary for UK tax purposes because she's deemed domiciled. Therefore, both jurisdictions will try and tax her on her worldwide estate, and you will appreciate that it would seem grossly unfair for both jurisdictions to tax everything at 40% because the beneficiaries will be left with almost nothing. The US and the UK have a fairly extensive gift and estate tax treaty, not to be confused with the double tax treaty, which deals with income taxes and capital gains tax, but the gift and estate tax treaty, which deals with matters such as these, that lays out a series of rules that say, in a given circumstance, with the individual in question, one jurisdiction should, where tax is levied in both jurisdictions, have the right to levy tax, and the other jurisdiction should offer a credit. Now, the determination of which jurisdiction has the primary taxation rights depends on the facts in each case, and it will depend on how long Mrs. Jackson's been here, is she a US citizen, is she a UK citizen, and possibly even down to a series of tiebreakers as to which jurisdiction was she most closely associated with. Where it becomes murkier and trickier and appropriate advice should absolutely be sought is in fact not where there is tax in both jurisdictions, but where there is only tax in one jurisdiction. Again, I referenced the example of where tax is not paid in the US because it's under the available balance in the US, but tax is paid in the UK because you're over the allowances in the UK. In those circumstances, you want to make sure that your family member, your client, whoever it is that is the person in question, still can claim the relevant relief for tax paid in one jurisdiction, even if tax is not levied in the other. It's not always possible. It really depends on the facts and circumstances, but it is just worth pointing out here that the estate tax treaty can, in the right circumstances, be your friend, but it must be considered very carefully because every situation is different. The only other thing I want to mention at the end of this episode, which I mentioned at the top, was a quick reference to a form of US estate planning, which is very common for Americans, which is the use of revocable trusts, living trusts, as part of will planning, and how that can have complications in the UK. I don't want to dwell on this topic because it's a very meaty topic and it definitely deserves an episode in its own right, but it's highly relevant to probates, and so it needs mentioning here. Because of Americans and their attitudes towards probate, it's very common for assets to be left through a revocable living trust during the grantor's lifetime, meaning that on the death of the grantor, i.e. the person who set the trust up, probate isn't needed because the assets are still titled with the trustees of that trust rather than that person in question. That's wonderful from a probate perspective because it means you avoid all the hassle and cost of probate that we discussed at the beginning. It doesn't matter for US tax purposes, we've always understood, because these things are generally transparent for US tax purposes, and so it's as if the person was still holding the assets in their own name. All well and good. The problem is that those trusts may not be considered, and increasingly are not considered, transparent for UK tax purposes as well. And if you have a Mrs. Jackson's daughter in the UK, if Mrs. Jackson had left a living trust in the US with some assets in it, and Mrs. Jackson's daughter in the UK is now looking to inherit, the UK tax treatment of those inheritances via that revocable trust can be very different to the tax treatment that her son would receive in the US, or indeed if there was no revocable trust there at all. Once someone has passed away and that trust has crystallized, there's usually very little that can be done about whether tax is due. All you can do is just try and mitigate the tax under normal trust tax circumstances, and we recommend that you speak to us urgently if that's your case. If Mrs. Jackson was still alive, there may be things we can do about that trust to mitigate the likelihood that HMRC finds that trust is not transparent, but it is simply a key example of the ways in which the US and UK tax regimes differ substantively, and it needs to be warned at this point because it often forms the basis of confusion when it comes to US and UK probate. At which point, I think that probably wraps up this episode. I just wanted to say thank you so much to James for coming onto this episode to talk about estate administration and US and UK probates. James, for those listeners that have lasted this long, what do we think are some of the salient takeaway points that people need to think about if they are not yet in the scenario where a loved one has passed away and so there is still time for some planning, or indeed if they now find themselves in circumstances where someone has passed away and they find themselves sort of cut adrift, not knowing what to do next? What would you recommend for those people?
Absolutely. Well, I mean, the key to this, I think we've referred to it throughout, is really lifetime planning. It's to ensure that the individual, the beneficiaries, the executors, all on the same page. UK, US advice has been taken in both respects. The will is as efficient as it can be. The plan is as efficient as it can be. Plainly, no one wants to pay more tax than they need to. So spending a bit of time, effort now to get your affairs in order is worth it in the long run. And as we've highlighted, the tax implications of not doing so are quite drastic.
Absolutely. And the only thing I want to add is, I think the same point actually that one of my guests on the Tanager episode mentioned, which is come to us and give us all the facts. Don't think that something is not relevant because you don't think it's relevant. So matters like US assets, whether someone was born in America, everything can be relevant. So come to us. We're happy to discuss things with you. We will happily tell you if you don't need to worry about UK tax, but we'd much rather that we have the opportunity to tell you that there isn't any UK tax due than you think there probably isn't any UK tax due and so you haven't asked. That all being said, thank you, James, very much for coming on to this episode. Thank you to you, the listener, for listening. And we'd love it if you join us again for another discussion of UK-US wealth matters.